Okay, ladies and gentlemen, we're not going to do that song. Gentlemen and ladies, because I don't want to hear that song right now. Ladies and gents, but I can listen to The World is a Ghetto by George Benson. We're here to talk about EFTs and closed checking accounts. Now, want to make sure all of you understand, because many of you have been misunderstanding what a closed account is and what a closed account is not. Okay? I'm going to show you two things. I'm going to show you what this person wrote, this attorney. Notice what this person wrote. I tendered an EFT for a closed account credit card debt. Okay. I tendered an EFT for a closed account for a credit card debt. It was accepted and posted to my account and then later adjusted. I claim that the acceptance and no return of the instrument discharged the debt and ended the contract. Many of you have been told stupid things like this because they want to tell you that dishonor because of UCC 3-603. Now hold on. The judge said that the defendant claimed that UCC 3-603 permits a person to discharge an obligation by using a closed account that has no funds is baseless. Did I discharge the debt and aren't all closed accounts without funds? Thank you. Ladies and gentlemen, wrong argument. Sorry. When you're going before the court, this is what you want to focus on. This is a legal term. Legal term. This legal term must hinge on one thing. The legal term definition. Now, this legal term is not according to what the courts say it means. They don't have that discretion. Okay? See? Meaning of closed checking account as a legal term. Now, I want to promise all of you, even though I had this up, I didn't even see the legal term. I didn't even see that. I'm just letting you know that a closed account, when you look in Black's Law Dictionary, closed has one definition and closed account has a different definition. They're two separate legal terms. Now, hold on. Let me show you why I can say that, because I understand. Not that one. I'm going to have to go back because there was a case I looked at. So, yeah, if I go back, then I can't go back. You can't go back. I got to go back. Oh, don't go back. You might hurt yourself. There might be somebody waiting around the corner. Ladies and gentlemen, we have to go back because we're going to forward this one. Watch this. Forward, forward, forward. Open a new tab. And while that's opening in a new tab, we come back to where we were. Okay, now I want y'all to pay attention to this. Okay, we're looking up closed account in this article. See? Each return check was marked closed account. So it's not a check. The moment he wrote closed account, distinguished it from being a check. See, a check must be backed by funds in an account. However, a closed account does not need to be backed by funds. Whew. Now hold on. Now remember, he says closed account. Now notice what they say. In appeal, Sykes did not dispute that he wrote the 5 bad checks at issue. So he admitted it in this account on bank accounts that were closed. He contends, however, that the trial court inappropriately and misappropriately and improperly and didn't do what they were supposed to do upon the presumption of fraudulent intent under the code to convict him of issuing 5 bad checks. No, I didn't issue no checks, sir. I tendered payment. We're going to talk about that in a minute. Because the presumption expressly arises only when a check is drawn on a bank in which the maker or the drawer has no account. Pay attention. This is what the individual is saying, and he's absolutely right. I had an account with that bank, but it was closed, the court would say. No, the account remains open. The account never closes. This is a legal term, This is a financial institution understanding and not a common sense, common law understanding. A closed account remains open for adjustments and set-offs. Now, today, the banks will say, no, that's for us to do adjustments and set-offs, just in case you have a remaining balance, unpaid balance, or just because there are other blah, blah, blah that comes up. No, a closed account, according to this court, means closed. That means there can be no adjustments and no set-offs. But the legal definition for the legal term says it remains open for adjustments and set-offs. The Virginia state law says that anyone who writes a check on an account where they do not have an account with the bank shall be guilty. Okay, so that's forgery, people. That's where you write a check, it has somebody else's name, but you put that check, that fake check, as payment for a debt. You have done a fraudulent transaction, and your intent the entire time was to commit fraud. Okay, under the statute, from writing a check on a bank in which the writer has no account, because unlike a check written on a non-existent account, he said this correctly, and that means he had somebody helping him. A check written on a closed account simply does not demonstrate on its face that the drawer intended to commit fraud. This is so, he argues, because a check writer's bank account could be closed through no fault of his or her own. Okay. Moreover, he argues further, unlike persons having no account, let's see, holders of closed accounts could have credit with the bank. That's right there is irrelevant. The legislator, he asserts, considers the difference between writing a check on a closed account and a non-existent account so substantial that despite the specifically referenced both type of accounts in code, despite specifically referencing both type of accounts in the code, it intentionally omitted the writing of checks on a closed account from operation of the presumption of fraudulent intent contained in this code. Accordingly, he concludes that the trial court erred in determining that this code, the presumption of intent to defraud, applies to one who writes a check on a closed account. No, it does not. Okay? Does not, because the account remains open for set off and discharge of debt, not of credits. Okay, eventually this person was found guilty, you all. Okay, let's go here. Notice what the court said. Let me tell you how they got around this on him. And I just saw this morning. It took me less than 5 minutes to go over this and realize all of the technicalities the court was using and the fact that the individual didn't highlight the point. Common sense and reason dictates that a closed account is an account that, for all practical purposes, no longer exists. Liar, ignorant, stupidity. In common parlance, the verb close means to bring an end or preclude from continuation of. Webster's Third International Dictionary uses an English dictionary to say that he is translating a legal term. So hold on, let's do this because we gotta do what the court said. Okay, because he purposely used an English dictionary and I didn't even recognize he used Webster's. Okay, CLOSED. And we do LEGAL. No. Can't do legal. No, let's do legal. LEGALDEFINITION. All right. We're going to do the legal definition for closed, not open. Okay? He says the legal definition for closed is not open, of a business having closed or ceased trading, especially for the short term. In a society system, no communication with or influenced by others, independent. Okay? Closed session, closed doors. Definition for closed, okay, means it ceased to exist. Now, watch this. New edition. Can you stand the rain, y'all? Look at that. Look at this. A closed account in legal definition. A closed account means an account which no further credits or debits can be added. Such an account remains open is the point. It's a legal definition. Okay, was he not trying to do a set-off? Of course he was. Statement regarding debits and credits between parties in a closed account cannot be altered. We don't care about that. But pay attention, ladies and gentlemen. This is the definition today. This is not Webster's definition. This is a legal term. And they forgot to mention that. Okay, but here's the part that people are not getting. A closed account is distinguishable from an account stated. The account stated, and it says it's distinguishable from an account stated because the account stated remains open. Or excuse me, closed account is distinguishable from an account stated. So let's look up account stated. That's what I didn't do. And the reason why I'm stopping, because I was going to say account stated is a different thing, a different term, a different legal definition, which is the reason why I was doing this. LEGALDEFINITION. And ladies and gentlemen, do you see? Oh, God. Account stated in legal definition. An account stated is a statement between a creditor and a debtor based on a series of prior transactions. Hence, an account stated arises in a particular account owned by a creditor or debtor to a certain date. Okay, pay attention. Ladies and gentlemen, this is the definition we want. You see, a closed account is distinguishable from account stated because the account stated is just statements. But a closed account remains open. So it is not closed. So the definition, the word closed is a misnomer. This is a legal term, and it must convey the understanding of the actual term. It is not closed. An account never closes. The bank does not have the authority to close it. Thus, the law says it remains open. But ladies and gentlemen, as we told you, you don't need to use the closed checking account. You don't need to do that anymore. You just need to tender payment. So what I'm going to suggest to all of you, when you're using the 445 form, put on the top of the form, tender of payment, put that in quotations. That's a legal term, as we talked to you about the other day. Put the legal term in quotations and tender your payment. You see, in this case right here, we're not going to go too much longer, but in this case right here, the court acknowledged. Now remember, the court says in the legal context, close means, excuse me, pay attention, to finish, bring to an end, conclude, terminate, complete, wind up, as to close an account. Black's Law Dictionary, 254, 6th edition. Ladies and gentlemen, no, please understand. He took this legal term and implied under presumption that it meant this legal term because the individual did not specify this legal term. See, he talks about common sense and reason. The courts cannot use their own rationale. They cannot reason. Accordingly, a closed account is one which has been ended and thus has ceased to exist. Excuse me? I thought it remains open. Okay, consequently, when a check is written on an account that has been closed, it is drawn on no account. Oh, you no account, mother. Okay, anyway, ladies and gentlemen, not true. See, he says consequently. Now, is he allowed to do this? Is he lying? No, he's consequently basing his consequently on this understanding because the individual failed to highlight that closed account is a legal term and they must apply the legal term to the statute. The statute does not reference closed accounts because it cannot. Why? Because the account remains open for adjustments and set-offs. So Sykes points out that there could be Instances in which a person might unwittingly write a check on an account that he did not know had been closed. And previously mentioned, however, the presumption of fraudulent intent arises under the code is rebuttable. So he's saying it's a rebuttable issue. He gets to rebut the intent. Intent is everything. Thus, when the court is presented with evidence that a defendant has written a check on a closed account, and they have evidence because he said it, okay? The court is presented with evidence that the defendant has written a check on a closed account. The defendant is afforded an opportunity to offer evidence that shows that the check was not written with fraudulent intent. There you go. He did not speak about the closed account. Oh, by the way, hold on. You see how this is not quotations. See, thus, when the court is presented with evidence, the defendant has written a check on a closed account. No, I haven't written a check on a closed account. I've written a EFT with my closed account, not on the closed account. Remember, that's another legal understanding, legal term. See, on a closed account, excuse me, why would you use the word on? That sentence doesn't even go together because he's using legalese. Okay, and the individual did not rebut the presumption. Further, Slike points out that the term closed account appears in the code, but not in this code. He's absolutely right. They're two separate, distinguishable terms. Citing the rule of statutory interpretation in Williams versus Matthews, thank you. So he did do something right, okay? So he didn't mess up completely when he wrote the court, okay? Because pay attention, statutory interpretation, that when the statute contains given provisions with reference to one subject and omissions of such provisions from a similar statute dealing with a related subject is significant to show the existence of the different legislative intent. He argues that the omission of the term, thank you, he did highlight it was a legal term. So I wonder if he went back on appeal and corrected this. The code demonstrates that the legislative intent to exclude the act of the writing a check on a closed account from operation or presumption of fraudulent intent contained in the statute. Sykes' reliance on the rule is misplaced. Excuse me? How's he misplaced? No. Facts and conclusions of law. In any prosecution action under the preceding section, any notations attached to or stapled upon a check, draft, or order which is refused by the drawee because of lack of funds or credit, barring the term insufficient funds, uncollected funds, account closed, or no account in this name, or words similar import, shall be prima facie evidence that such notation is true and correct. Prima facie evidence. Okay? That means that because the bank stamped it that way, he doesn't get to argue the point. He has to now rebut the presumption that the account was closed. All right, let's do this. 18-214 is a rule of evidence that, in conjunction with the code, aids the Commonwealth in proving a drawer's fraudulent intent in cases like this. It allows proof that the lack of funds in an account or the absence of an account to be established simply by the language of the drawee's bank stamp on the check identifying the reason that the check was refused. As listed in code blah blah blah, the term not sufficient funds or pay attention, not sufficient funds and uncollected funds both indicate that the check was refused by the drawee because there was insufficient funds in the existing account upon which the check was drawn to cover the check. Such evidence, if unrebutted, like I said, okay, it's legalese, people, would invoke the presumption prescribed in the first paragraph of the code. Conversely, the term closed account and no account in this name both indicate that the check was refused because the account upon which the check was drawn does not exist. No, because all he has to do is show proof that the account did exist. He hasn't rebutted the presumption. Okay? That evidence would give rise, if unrebutted, he hasn't rebutted the presumption. I haven't read on, people. I'm just reading this for the first time. that the presumption at issue here, which is set forth in the last paragraph of the code, thus, rather than showing that the legislative intended to exclude closed accounts from the operation of the code, presumption of fraudulent intent, as Sykes claims, the language of the code clearly places the one who writes the check on a closed account within the scope of this code. Provisions of one act which are omitted in another on the same subject matter will be applied when the purposes of the two acts are consistent. You see, he wasn't a lawyer and they didn't know these things. Lastly, Sykes asserts that one who has a closed account could still be extended credit. That's a moot argument. It doesn't work. Okay, here is the code. This is what they accused him of. Well, actually but this is the other part of the code. Any person who, with the intent to defraud, shall make or draw or utter or deliver any check, draft, or other order for payment of, order, pay to the order of, money upon a bank. Nobody's doing this for payment of money. EFTs are not for money. Didn't know that, did y'all? Banking institution, trust company, or other depository, knowing at the time that such making, drawing, or altering, or delivering, that the maker or the drawer had not sufficient funds in or on credit with such banking institution, trust company, or other depositories for the payment of such check, drafts, or order, although no express representation is made with reference thereto, shall be guilty of larceny. Oh God, he's a larcenist. Oh, he's a larcenist, y'all. Okay. In any prosecution or action under the preceding section, the making or drawing or altering or delivering of a check, draft, or order, payment of which is refused by the drawee because of the lack of funds, and credit shall be prima facie evidence. See, lack of funds and credit shall be prima facie evidence of intent to defraud or knowledge of insufficient funds in or credit with such banking institution, trust company, or the depository, unless such maker or drawer or someone else for him shall have paid the holder thereof the amount due thereon, together with interest and protest fees, if any, within 5 days after the receiving of the notice that such check or drafts or order has not been paid to the holder thereof. Ladies and gentlemen, if they say that's why you have to tender payment, if they give you a notice of insufficient funds, according to this law in this state, you have to notify them, oh, no, this is on a closed checking account. There are funds there for you. This is for you to, don't say there are funds. This is for you to offset the balance by tendering this payment through that account, which remains open for set off and adjustment. So you're to offset the balance in this account. Okay. Pay attention. Notice mailed by certified or registered mail, evidence by return receipt to the last known address of the maker or drawer shall be deemed sufficient and equivalent to notice of having been received by the maker or the drawer. Do you guys understand? Priority mail, so you can document that you sent them payment. Just that simple. I mean, really is just that simple. Okay, now, hold on. Let's read the rest of this because it's not that much longer. That's the end of it. If such check, draft, or order shows on its face to be printed or written, address, home, office, or otherwise, the maker or the drawer, then the foregoing notice, when sent by certified, registered, or other such mail to such address, with or without return receipt requested, shall be deemed sufficient or equivalent notice of having been received by the drawer or maker, whether such notice shall be returned or undelivered or not. When a check is drawn on a bank in which the maker or drawer has no account, it shall be presumed that such check was issued with the intent to defraud, and the 5-day notice set forth shall not be required in such cases. Okay, when it says the individual had no such account, okay, pay attention, people. The account is still there. It never closes. it's still there. That's why they're able to pull up the information. If the account didn't exist, the bank wouldn't have any information. So all you got to do is pull out a statement saying, of course I have an account with this bank. And this is a closed account. So as the issue is not before us, pay attention, as the issue is not before us, the existence of some other unrelated account between the bank and the check writer is not relevant in this discussion. Does he have another account? See? Or unrelated account? Does he have some other account or unrelated account? A closed account is a closed account is a closed account. You can't get away from that. It's a closed account. All right. Pay attention. Closed account definition. We're going to click there. See, the people who are asking lawyers, and I don't know why they would do that. Excuse me, Mr. Lawyer, can a closed account be used to offset blah, blah, blah? We're going to go with the legal definition because it's a legal term. Closed account, a detailed statement of mutual debit and credit demands between parties, which no further changes can be made by either side. A closed account is distinguished from an account stated, which remains open for the purpose of adjustments and set-off. Now, an account stated, this is an account stated, people. A detailed statement, this is a statement of account. Statement of account, account stated. That's why they wrote it that way. So this is a statement of account. That's why they're always giving you statements, telling you here's proof. Oh, no. I want a comprehensive audit. Okay. A closed account is distinguishable from an account stated. The former closed account remains open for the purpose of adjustments and set-off. See, if you're reading this, because when I read over it today, I was thinking, wait a minute. So a closed account is distinguishable from an account stated because an account stated remains open for the purposes of adjustment and set-off. But not true. Not true. This is the definition that they put today. But if you go back to Black's Law Dictionary, when it was done, it is the closed account that remains open. Okay, as we showed you earlier. So hold on, we're going to go back. Back. And we're going to go here because this is the same thing but in Bing. Closed account. Closed account means an account to which no further credits or debits can be added. Such an account remains open. Okay, so it's not the account stated that remains open. It is the closed account that remains open. Pay attention. It's not the definition of today. It is the definition of when the legal term was invented, created, or brought into fruition. Okay, so it is the legal term. Closed account means a closed account. The word closed has nothing to do with anything. The fact that it's any type of an account means that an account exists. Look, a closed account is any account that has been closed out or otherwise terminated either by the customer, custodian, or counterparty. The term accounting procedures, a company will close, blah, blah, blah. You see, they're talking about the definition of today. Okay, we're not dealing with closed, because that's where that idiot went and pulled up the definition. Closed account is a legal term, everyone. Legal term. Okay, here it is. The law, it says closed account, an account which no further credits or debits may be added. Such an account remains open for adjustments and set-off. The statement regarding debits and credits between parties in a closed account cannot be altered. We don't care about that part. That's been added later. Okay, the original definition didn't say that. This is the definition for a closed account, people. So, for those of you who didn't know whether or not you could do an EFT, you can do an EFT. Would I advise you to do an EFT? No, not really. But is it legal? Can you do it? Yes, you can. The law permits it, but you have to be able to explain it. Okay? You know, I haven't heard of Nina. You guys remember Nina with the EFTs? I haven't heard from them 2012 was the last time I heard of Nina. But oh well. Hey everyone, I just want to say thank you for taking the time to be here to listen to me talk about EFTs and closed checking accounts so that you will have your information. Hey, less than 30 minutes. Have a good day.